We can make a start as everybody starts to join. I'll just sort of run through sort of context of the call and some introductions, and hopefully by that time everybody who's going to join will be on. So first of all, just a small piece of housekeeping. Hopefully you can see on top of the call, this call is being recorded, so hopefully that's okay with everybody. And yeah, so welcome to our employment law update. So this is basically following on from a series of in-person events that we did with Forbes, obviously around what we were hoping to see change-wise from the Employment Rights Bill. As we know, that pesky Labour government didn't quite have it published in time, so a lot of the pieces that we run were sort of scenarios and pieces around that. But obviously now, with the introduction of this webinar that we have today, this will sort of go and look through what's actually been confirmed and obviously Joe and Laura's thoughts on this. So to introduce myself, I'm Remy Kaplan, Client Director for Hays, and today the session will be run by Joe Handler and Laura McHugh from Forbes. So to give a little bit more context to who we'll be speaking to, Laura is a partner in the public sector team working across Forbes Manchester and Lancashire offices, mainly supporting housing associations, local authorities, schools, colleges, and some academy across the country. Joe Handler is a senior associate and predominantly works with the employers in the private sector across a range of sectors such as retail, hospitality, manufacturing, and professional services. So they will be taking you through today's session. So I'll hand it over to both of you ladies. Thanks very much, and cheers.
Thank you. Thanks for that, Remy. And just before we go into the session, I'll just say that in terms of timing wise, we've got an hour today for this session. There's obviously quite a lot for us to go through, but we have tried to keep a section of time towards the end for some questions. So if you do have any questions throughout the session, please put them in the Q&A function box, and hopefully we'll get to those at the end. If we do run out of time to do all of those questions, then we will do our best to get responses to you as a follow-up after the session itself. And you will also get a copy of the slides, and the recording itself can be made available to you. Okay, so we'll go straight into it then. Thanks, May. Okay, so in terms of what we're looking at today, obviously it's the Employment Rights Bill, the changes that we now know are going to be coming at some point. So in terms of where the land lies, really, the situation just before we got the bill, what were people thinking would come? What was their sort of thoughts going into the change that was coming? We looked at a survey which was done by Opinium, and that was launched and published, just a week before the bill came out, and that revealed that 66% of business leaders, they thought the reforms would positively impact their operations. We also obviously had views from the trade unions. The TUC General Secretary, he said most managers understand that if you treat your staff well, they will perform better. We also had Tesco's chief executive urging the government to collaborate with businesses on the new rules to ensure that they didn't inhibit growth. We've then had the bill, and we've obviously had a different range of reactions following the publication of the bill, some of which I'll go into in a bit more detail. One of them in particular I thought was interesting. We had the chief economist at the Institute of Directors who said that the new legislation had the potential to weed out unfair employment practices, but warned of the increased cost burdens, which could lead to reduced employment operations in the future. Again, going back to the trade union side of things, the TUC said that the Employment Rights Bill, if delivered in full, would make work better for millions of working people. So there's quite a lot in terms of different positions, in what the bill can do positively for making work better for a lot of people, balanced against the impact that it might have on businesses, which we'll talk to you throughout. So if we just move on, I'll just briefly go through the background again in terms of how we got here. I know many of you will have attended other sessions, so I won't spend too long on this. But in terms of what we have expected and how this marries up with our expectations prior to the bill coming out, I think some of those have been met. But in terms of the big all singing, all dancing change that was going to happen imminently, I think we've been surprised that actually a lot of things are going to take longer to be implemented. So in terms of how we got to this position, just to reiterate, when Labour won the general election, obviously they promised these wholesale employment law reforms. They committed to laying those down before Parliament within the bill, within 100 days of them coming into office. So at the time when they said that, it did seem like an extremely tight timescale for these kind of potential all-encompassing changes. However, the government did meet their commitment, and on the 10th of October, the Employment Rights Bill was published. When that was published, the press release accompanying that said that the Department for Business and Trade described the reforms which the bill introduces as landmark reforms, which will help to deliver economic security and growth to businesses, workers, and communities across the UK. In terms of where we're currently at, the bill passed its first reading with a majority of 281 votes, quite substantial, but again, makes sense if you think about the makeup of the seats they have. And this essentially will potentially grant new rights to employees related to sick pay, to flexible working and paternity leave, to name a few. However, I mentioned the different opinions in terms of how it's been received, and there has been some, what I would describe as quite significant criticism, particularly from the Shadow Business Secretary, who warned that it could create a crisis of magnitude not seen since the pandemic for small businesses. So that's fairly strong words there. And Mr. Hollingray told the Commons, "The question I ask myself now is, when this legislation is in place, would I start that small business again today? Sadly, the answer would probably be no, certainly not one that employed any people." Again, quite strong words there. Now, the government obviously had to look into the potential impact of their changes, and their impact assessment indicated that the reforms will impose a direct cost on businesses. And they've said that that could be around the 5 billion mark annually, with small and micro businesses expected to bear quite a disproportionate burden within that. As we expected, trade unions have had a slightly different view, and the TUC has welcomed the bill, saying that the legislation is good for workers, good for businesses, and good for the wider economy. The General Secretary, who I mentioned earlier, also said that by levelling the playing field on workers' rights and protections, this bill will give more people predictability and control over their lives, and it will stop decent firms from being undercut by the bad. So in terms of these changes then, are they likely to be imminent? And first of all, I think it's worth pointing out that not all of the reforms which Labour proposed to make do require primary legislation. Some of the changes can take place via codes of practice. Some of them can be changes to the remit of existing bodies, such as a low pay commission. We also don't have a set date for when the employment law reforms will take place. That would have been very nice for us all if we had certainty to work towards, but unfortunately we don't quite have that. The bill itself will need to go through the parliamentary process, as it's already doing. There'll need to be further scrutinisation by MPs and peers, and that could result in amendments being made to the original proposals. The government, when it published the bill, also brought out a next step document in terms of making work pay. And in that, the government confirmed that they expect to begin consulting on reforms in 2025, and that reforms regarding the right to claim unfair dismissal, for example, we all know that's a big one, that will take effect no sooner than autumn 2026. So it does appear then to us that these changes will be happening piecemeal. What that means really is that organisations will need to keep up to date. They'll have to keep appraised of this ever-evolving employment law landscape that we now have. And part of that is that the government is wanting consultation and it's wanting views on some of these proposed changes. So if we just move on to the next slide, we'll see that there are already a number of consultations which are underway. They've been opened by the government, and there's quite a tight time frame around those. So the ones that we're going to talk about in this session, we'll go through them as we talk about the changes in turn, but they're due to close in less than 6 weeks. I think the 2nd of December is a closing date for some of these. So there isn't much time for businesses or other interested parties to respond to these, and they are worth going away and looking at. What we have in particular, we've got a consultation open on collective redundancy and fire and rehire. So that's number 1. We've got number 2, strengthening sick pay. We've then got a 3rd consultation, which is creating a modern framework for industrial relations. And then fourthly, we've got consultation on the application of 0 hours contracts and measures specifically in relation to agency workers. So as I say, we're going to consider in detail these consultations in conjunction with the changes that the government is proposing within the bill. And I'm going to hand over to Jo now to take you through those in more detail.
Thank you, Laura. So just move to the next slide, please, May. So Laura's giving you a brief overview. October, big day, 28 reforms that talk about creating a new single enforcement body. So lots and lots of changes. But now we're going to talk in a little bit more detail about what they actually mean for businesses. So we'll do that first. There are also a few things that happened in the budget last week, which we're going to touch on at the end as well, because highly relevant and probably in some ways more pressing than some of the things we're going to talk about from the Employment Rights Bill. So we'll talk about those at the end. So if we just go to the next slide, please. Before we get started, it'd be really good. I would have loved to have done a poll and you could all vote. I have listed in there all of the different, summarised all the different changes. So there's a lot of things going on. For some of you, you'll be familiar with the detail. For some, you won't be aware of all of them. What I would love you to do is actually, we've had to change the technology, vote for one. So in a second, can you pick, now, we've made it a little bit unfair. Day one unfair dismissal rights, I think, would probably be the top of the list for what is going to have the biggest impact on your business. We're not letting you vote for that one. So can you have a quick look at the other options and see, of all the changes, what do you think is going to have the biggest impact on your business, or what are you most worried about? If you just quickly vote, it will just give us a sense check of what people are worried about in the workplace. And our glamorous assistant May will in a second put the figures up. So they've got changes to statutory sick pay, flexible working, fire rehire, trade union reforms, taking all reasonable steps to prevent sexual harassment, changes to 0 hour contracts, collective redundancy, menopause action plans, lots of different NMW rates, ethnicity and disability reporting, so many different things going to be on the horizon in the next 2 years. So let's just see where we get to now we've done the votes, please, May. So 0 hours contracts is definitely a big one, and flexible working. I think that's all. Let's scroll down. So yeah, 20, you can all see this as well. 23% say flexible working, 22% say changes to 0 hour contracts. And I think, oh, I've just lost my poll. There are probably some more as well. Laura, can you just read out some of the ones at the bottom? So are there any more big ones?
Yeah, I'll just go through. I think the big ones you've talked about, duty to take all reasonable steps to prevent sexual harassment is fairly big at 9%. Single worker status actually has got a few votes. Trade union reform, 7%. And national minimum wage rates, as you've mentioned. Yeah, those look like the main ones.
Great. Well, that's really interesting because obviously I think unfair dismissal day one rights were probably the top of everybody's list. But we did cheat. So if we just move to the next slide, please, May. Let's look at that one first of all. So you'll all be aware that currently you need, we call it a 2 year qualifying period. It's actually 1 year and 51 weeks plus your statutory notice to bring an unfair dismissal claim, unless it's one of the special characteristics like whistleblowing or a discrimination claim. So that has been much talked about, and a lot of scaremongering has been going on in the sort of press in the months leading up to the Employment Rights Bill being issued. So lots of concern. This was going to be a massive drain for business, a massive fetter. And there's a real pushback about what's going to happen about probationary periods. So huge relief. They've now said that technically they're still saying yes to our day one unfair dismissal rights, but there will now be this possibility of a fair dismissal during an initial period of employment, or when notice is given during that period and the affected date of termination falls within 3 months of the initial period of employment. And the reason is for capability, conduct, statutory contravention, or some other substantial reason, then it can potentially be fair. The thing that is excluded from it is redundancy. So under this new arrangement, somebody could start work, and if you suddenly have to close a factory in 2 weeks, they will have exactly the same unfair dismissal rights as somebody that currently you have to go through that process of consultation and scoring. So that will be a change. But where you're looking to dismiss somebody primarily for capability or conduct, you will be able to go through this initial period of employment dismissal process. Now, this effectively means that the bill will allow employers to operate probationary periods, which is really good news for everybody. And during that process, you will still be expected to go through some sort of process, but it'll be a lighter touch. At the moment, we don't know exactly what's going to entail, but you'd expect there to be a meeting, probably clarification of the types of issues. Who knows about the right of appeal, but certainly you can't just do what currently some employers do, is call people into a meeting and say, actually, it's just not working out. We'd like to end it, please. And here's your notice pay. That currently will not be allowed. We need more details through consultation, but it's a big change. What has been useful since the bill came out in October is the government's preference is for a 9-month probation period, which I think is very, very welcome. Now, it's going to be subject to consultation, extensive consultation, so this hasn't started yet. And it'd be interesting to see how this statutory probationary period sort of interacts with the ACAS Code of Practice as well on disciplines and grievances. There's also speculation about how the compensation will work. You know, is it going to be a limited amount of compensation for someone who's dismissed in that probation period, or will it be the full unfair dismissal compensation people can get now? Now, there are some different possibilities about how the claims will be treated. So one is that currently, as many people will know, if there's an unfair dismissal case, it's for the employer to show that the dismissal was within a range of reasonable responses. So one option is that under the new framework, that perhaps dismissals during the probationary period will be deemed to be automatically fair if it's for one of those conduct, capability reasons, etc., unless it's wholly perverse. I think that's unlikely. I can't believe there'll be a default that it's fair unless we show it's not. But you never know. Let's see what the consultation says. Another option is, which people who've been doing this for as long as me will remember, we do remember the statutory dismissal procedures we used to have way back in 2010, I think it was, where there was this minimum dismissal process you had to go through. The speculation, could something like that come into play, where there are very minimum levels of things you have to do to go through that? So I think there'll be a lot we have to look out for. Consultation on this will be critical. So I think we do need to watch out for that. I mean, from a risk perspective, it's huge because many employers do definitely treat that first 2-year period with a lot of flexibility. As long as there's no protected characteristics, they are quite relaxed about dismissing people on notice. And people then, even outside of probation period, will be fairly relaxed about how they do things. So it will definitely change cultures within the company. So whilst it may not come in until the autumn of 2026, once we do know how it's going to come in, you will need to check your contracts, you'll need to check your probation periods, you'll need to train your managers to make sure they're actually using those probation periods to manage and assess performance, because you can't just turn up to a meeting and say, we're going to let you go, here's your notice. You'll need some evidence, I would imagine, of where the poor performance issues lie, whether you need to go through a fair process of letting them improve and set targets, hopefully not that detailed, but you won't be able to do it without any evidence. So it's really a mindset change as well for the employers that they need to get into that. By doing this, the government's estimating that more than 9 million additional employees will be able to bring unfair dismissal claims, which for a tribunal system that's already highly under stress will be, I don't know how they're going to resource this, but that's obviously what they're trying to do to protect everything. Can you just have the next slide, please, May? So another day one right, paternity leave and parental leave, not so controversial. It seems fair, really, that sometimes you've had to have 26 weeks service by the 14th week of the baby being due, etc. So quite complicated area. So this is a welcome change. But the big problem, I think, for many employees in terms of uptake of these benefits is it's not paid. So until these things are actually paid, we're unlikely to see a significant increase in the amount of people taking that type of leave. They're also going to extend bereavement leave from a day one right, and that will be to anyone who is bereaved, although the detail of the relationship with the employee isn't yet clear. Next slide, please. Statutory sick pay. On the face of it, I think this to me is quite an immediate direct expense for many employers. So a bit like unfair dismissal for day one rights. I didn't see how many people voted for this. So as many of you will know, if you operate SSP, there are currently 3 waiting days, but basically that means an employee does not get statutory sick pay until their 4th day of absence. And also on top of that, there is a minimum earning threshold. So if you're a low paid worker, you will not qualify for SSP. So the Employment Rights Bill has confirmed that they are both changing. So the waiting days are gone. So you will be able to get SSP from the very first day of sickness absence. As one employer said to me, that means somebody could start their job, do their induction and go off sick and they'd be entitled to sick pay. And I was like, yes, which is a bit frustrating, but that is the reality of it. So it's going to bring a lot more people into that very, very quickly. Secondly, the lower earning threshold will mean that, that's probably a fair thing to do because people on lower should be able to get some sort of SSP. There is government consultation on this as well. It's not particularly exciting. These 2 things are definitely happening, but what they are consulting on is what percentage of somebody who is a low earner what percentage of their salary will be paid as SSP. So we haven't put details of the consultation up for that one because that's all it is. It's not particularly exciting, but I think this is going to have a real cost for the business in the short term. And I think you need to make sure your absence policies, your return to work meetings are really slick, because you might find there's an increase in people taking the odd day here and there because they get paid for it. So it's really making sure your policies are really robust so that you can manage those as poor attendance if you need to through a capability process. Next slide, please. Collective redundancy consultation. As many of you will know, currently, if an employer is considering dismissing 20 or more employees, it's only if they're based at the same site. It's called the Woolworths case. So if a company has lots of different sites and they're dismissing 10 from one, 10 from another, they would not trigger collective redundancy. The Employment Rights Bill has confirmed that's gone. So now they will look at what number of redundancies an organisation is planning across its whole business and not at one establishment. And remember, this is a rolling 90 days. So that's a huge impact for businesses. And Laura will talk about trade union reforms later. It ties into that. Obviously, the Labour government is here to try and push and promote trade unions. So this is really going to make collective consultation much more common in what would otherwise be a redundancy situation that doesn't require that. So you need to be aware that this is quite a big change if you're doing restructures. Next slide, please. Fire and rehire. So again, a little bit of scaremongering before. There was talk that the Labour government would actually have an outright ban on fire and rehire. So I call it the old dismissal and re-engage, which sounds a bit less scary, but fire and rehire very Americanized. So there was speculation it would be banned in its entirety. That hasn't happened, but what it has said is it will be automatically unfair, so going back to unfair dismissal, to dismiss an employee if the reason is either that the employee refused to agree to a variation sought by the employer, or their dismissal is to enable them to take somebody else on or to rehire the current employee under the new terms and conditions, but with substantially the same duties. So it's there, you can still do it, but it's going to be much, much harder to do it, and it will be automatically unfair. A little bit like TUPE. If you dismiss someone for a TUPE transfer, it's automatically unfair. It doesn't care about reasonableness or anything else. Now, if you just go to the next slide, there is a slight get out of jail for us, because ultimately, sorry, May, the next slide, please. There is going to be an exception. You can read it on the slide there, but basically, in absolutely dire financial circumstances, the company can show that they had no option to do this, or the company might go bust. Then it might be allowed, and then they might not have all the unfair dismissal and be able to justify it. So again, we haven't seen yet how the detail will play out in terms of, is it a case of doing what you can to mitigate it, or there'll be a complete pass. But ultimately, it's going to be, this isn't a choice that people do because it's quite nice to harmonise terms and conditions. Convenience is not going to be enough. It has to be something that's going to save the business, save critical jobs, otherwise the company might struggle. So it's definitely a massive limitation. Next slide, please. So let's look at the consultation they're doing for redundancy. So we've already talked about the 20, if you're looking at to dismiss 20 employees over a 90-day period. What they're interestingly trying to do, so currently, if you are found to have failed to carry out that collective consultation on a redundancy exercise, employers are entitled to a protective award of 90 days pay. That's the maximum compensation based on gross pay. And then a tribunal would look at it and say, well, what have they done right? And they'll bring it down. The starting point is 90 days. What this proposal of consultation is definitely staying, but what they're saying is we're either going to double it to 180 days, that's a lot, or we're going to take the cap off it completely. So where there's been found to be, the company has not collectively consulted, there is no limit on the amount they can do. Now, the rationale for this, they say, is the majority of employers do actually comply. They do their consultation. There are just some that currently will basically buy people out of that. So think of P&O ferries, etc. I'm not looking at particular examples, but they know they're not going to bother with collective consultation. They will offer people more than 3 months pay, 90 days pay, to get the changes agreed, to get them to sign a settlement agreement, to get rid of a tribunal claim. So what the government wants to do is basically curb that type of irreverent, we don't care about the law, we're above the law, we can do what we like. So that's why they're coming up with this proposal to either have 180 days or an unlimited protective award. I think it's quite scary. You'd hope that when we work with most companies, they do want to do it correctly, or if they can't, it's because of financial reasons. But still, the lack of certainty definitely does worry me. So that's definitely one to watch out for in the consultation. That's one of the live consultations Laura has already referred to, and it closes in early December. So please make sure you do go onto there and go through the questions if you feel quite strongly about that. The second one is the consultation about the fire and rehire. Now, what they're proposing to do for this is actually make it subject to interim relief. This is actually for both. So people may be familiar with this, that if you're a whistleblower, if you're dismissed and you're claiming you've been dismissed because of whistleblowing, if you make an application within 7 days of dismissal, you can effectively say, please keep me employed. I can show you that I'm pretty much got a very good case. I'm going to win my whistleblowing claim. So you should keep me on the pay, on the salary until my claim comes to court. So they're very, very unusual cases, very specific for whistleblowing at the moment. But what they're proposing as part of this consultation is it would apply for collective redundancies and fire and rehire. So somebody who thinks they have a strong claim could make this type of complaint to a tribunal. You have a mini hearing, and if the tribunal agrees they've got a strong chance they may win, you as an employer have to continue to pay them, whether either they stay employed or just pay them a salary. And if that case is going to take 2 years to get to tribunal, that is a huge cost to the business. So this actually, to me, is a very terrifying change for employers. Whistleblowing is a very specific individual complaint on a case-by-case basis. If you're looking to make 100 people redundant because of mass reductions in your site or your business, and suddenly you might have to keep all 100 on the books for another year or 2 years while you wait for tribunal, well, that to me is a very, very different market. So as a lawyer, we should love all this. I would like, yes, give me interim cases, but actually I think it's very, very worrying for employers. Okay, next slide. Again, we had lots of discussion about they're going to ban 0 hours contracts. As Laura said, there has definitely been good communication with businesses. They have definitely reined back on that. But interesting that this is one of the big things you picked up on, that this is a big concern for your business. So what they're proposing to do is introduce this idea of guaranteed hours. So you'd work for 12 weeks, and then they'd look back at the previous period of work to see how many hours you've worked, and then you have the right to apply for these minimum hours or guaranteed hours contracts. So this would work for people on complete 0 hours, or it would also work for people who have like a minimum level, like you might do 10 hours a week, but actually you might be required to do more. Both of those would be covered by this situation. Now, you may remember the Conservative government had originally planned the Workers' Predictable Terms and Conditions Act 2023, which was meant to come into force in September, which was meant to deal with this and have a code of practice. The government has said that doesn't go far enough, so they're not bringing that into force. And instead, they're looking at changing areas under the Employment Rights Bill. So one thing you could be doing is looking at your organisation. Many of you will know you use them. I've got quite a few hospitality clients who use them very much to deal with periods of peaks and troughs, distribution in the run up to Christmas, huge areas. So there are also things that employees like, you know, they're actually good things. They like flexibility for students, etc. So I know I've got some people on the call today who I've spoken to before who do a lot of events management. It's very quiet over the summer. Absolutely having a bank of workers on 0 hours contracts that can be available if they want to work, and there isn't an exploitative nature to it. So it'll be interesting to see how the exploitative bit works. The other thing that we'll be able to do as well is if there are sessions they're meant to be working that get cancelled, they will be able to get compensation for that. So it will be a sea change. There is not a ban, which is good news, but you do need to be aware of how these work. And I guess, again, the devil will be the detail really in terms of what happens following the consultation. Next slide, please. So to have a quick look at what they're talking about in the consultation. So obviously the purpose of this is to try and stop vulnerable workers being exploited. You know, they're sitting around waiting for work, or their mental health is cancelled at short notice. And it's trying to tackle that one-sided flexibility in 0 hours. So as I've already mentioned, for a lot of people, there isn't that. It is a mutual beneficial arrangement. So the consultation will come in, and there's a lot still to be determined. So for example, if I'm just going to reel off some of the points in the consultation now, but I would encourage you, for 3% of you that think this is an issue, please do look at the consultation. So specific issues they're going to look at as part of this is whether agency workers should be offered guaranteed hours by the agency or by the end hirer. Obviously, they acknowledge that the agency really doesn't have much control over demand for hours. So it's interesting to see how that's going to play out. It might change the nature of the relationship between the end hirer and the agency worker as well. Maybe they'll make them more of a direct employee if they're having to do this anyway. It will also look at whether or not who's going to be responsible if shifts are cancelled at short notice. Should it be apportioned with the employment agency and the end hirer, or is it going to be something for them? They're looking like it'll be on a case-by-case basis. They'll also be looking at whether or not should be employment agencies can be allowed to recover the cancellation payments from the end hirer. Now, the government's suggesting from the consultation that they really don't want to have to deal with this in legislation, that they expect that to be picked up between the parties as part of contracts. Okay, next slide, please. Flexible working. I think this is your second hot choice of what is going to be an absolute nightmare. So again, lots and lots of scaremongering. Oh my goodness. You know, flexible working is going to be the default from day one. You actually have the right to work flexibly unless it's not reasonably practicable, for example. That's what a lot of the press headlines. Everyone will have the right to work a 4-day week. Fundamental changes. Has that happened? No, it has not happened at all. So if you remember, quite a lot of changes were made this year anyway by the Conservatives, probably in preparation for a general election, but they brought in the right to flexible working as a day one right from April. So we already have that right, so nothing has changed. When the Employment Rights Bill came out, we did think it might actually mean that we wouldn't be able to rely on those reasons that we currently have. They are still there to all intents and purposes. But what we will need to do is if an employer refuses a request, they'll have to give their reasons for that. Interestingly, while so much fuss has been made around this, it's still only a right to request flexible working. It's exactly the same. The fact we've kept those reasons is really important for employers. And also the penalties, if we don't comply with that process, if an employer doesn't, it's still only 8 weeks. So it's not a huge change that we expected. So that 23% of you that were worried about it, please don't. It's not as bad as we thought. And actually, there's a real sea change, I think, with a lot of my commercial clients, with banks, American businesses. They want people in the office more anyway. So I think there's a real disconnect at the moment between a lot of big corporates and what individuals perhaps and government want us to do. Next slide, please. Fair Work Agency. I don't know, I'll have to look afterwards if this was, anyone referenced this in the poll. I think this is actually quite a big thing. As somebody that works with clients on HMRC and NMW, National Minimum Wage audits, I think this is actually quite terrifying for employers. So a single enforcement body has been talked about a lot since 2019 in Matthew Taylor's Good Work Plan. It's been consulted about, nothing's happened. Obviously, we had COVID. But you'll be aware there are currently 3 enforcement bodies. HMRC deal with national minimum wage, the GALLA, Gang Masters and Labour Abuse Authority, deal with specific sectors, like is it shellfish, cocklefish workers, and people that work in the food industry. They also have a licensing arrangement for those individuals, but they also look at sort of trafficking and things like that. So that's almost like the criminal side of it. A lot of people that work there are ex-policemen, so there's a real enforcement, interrogation, lights in the eyes of the employer, whereas the NMW stage, not comfortable, but it's ultimately an audit. And it's very based on correspondence and things like that. So they're very, very different ends of the scale. The other body is the EAS, which obviously governs agency workers to protect them as well. So this talk will be the Fair Work Agency will have responsibility for all 3 areas. Again, the consultation will come. Who's going to have the control? Is it going to be a new one? We don't know. But interestingly, HMRC recruited 5,000 new inspectors just before the Employment Rights Bill was published, which makes me think they might know what's coming. And also they already use exactly the same software. So straight away, the way they'll be responsible for looking at holiday pay, for sick pay, COP3 agreements. It's a huge area, which will take a lot of potential tribunal claim away from the tribunals as well. If there are disputes about SSP or holiday, it will be the Fair Work Agency that actually go away and do this. So it will have real teeth. Next slide, please, May. So the government's made it clear they really want it to have powers to protect workers' rights and curb abuse. It will give the agency powers to investigate and issue fines, inspect workplaces, lodge civil proceedings, and ultimately take people to court and issue criminal cases against them as well. So it's a huge, huge area. There'll be a lot of powers that can come on site and interview staff. So this is definitely something to watch from an enforcement perspective. And I think if it's anything like NMW, that is very, very challenging for employers and finding the balance between educating employers to do things correctly, which I think is a lot of the mistakes with national minimum wage for a lot of companies who aren't disreputable, to the other scale of actually trying to seek out and enforce and prosecute people who are breaking the law. There is a consultation that's come out just on that, so we'll put that in the slides when we send those to you as well. Next slide, please. So we're going to talk about very briefly. Many of you will know already from the 26th of October, the Working Protection Amendments Act came in, which put a proactive duty on employers to take steps to prevent sexual harassment in the workplace for employees. The bill is proposing that if it's passed, it will actually be increased to all reasonable steps, and it will cover third-party harassment. So that was how it was originally intended, but as it was passing through the various parliamentary reading sessions, I think the MPs said it would be too difficult for employers to actually take all reasonable steps. How can you actually prevent sexual harassment happening? But they're suggesting it's going back in. It'll be interesting to see if it gets through parliamentary sessions, but if it does, that will place again a much higher bar on employers. The other thing as well they've confirmed is that sexual harassment allegations will be a form of whistleblowing as well. So all that things about interim relief, etc., will kick in for this as well. So again, it's just making it harder for employers to comply. Next slide, please. I'm going to whiz that quite, because I think a lot of you will be quite familiar with that. Next slide, please. And finally, for me, just looking at enhanced protection for pregnancy and new mothers. Again, in April this year, we had changes so people who are coming back protected from redundancy have greater rights to be considered for alternative employment. So this seems to be an extension of that. They'll be more protected. So it's not a complete sea change. It just means we think when people come back for 6 months after they've been on maternity leave, they are protected and it'll be hard to dismiss them. So we haven't had the details yet, but I think that's the way it's going to go. But again, probably won't be a massive sea change for people at the moment. So that's a very whistle-stop tour through some of the main things. I'm just going to hand back over now to Laura to talk about trade union reforms.
Thanks, Jo. Okay, yeah, so moving on to trade union reforms. I think there was an expectation that the bill would introduce quite significant reforms in this area. And if I was asked whether that's been materialised, I think I would say yes. I think there are quite significant changes which strengthen the rights of trade unions. The government, prior to the bill coming out, did say that its intention really was to reset industrial relations between unions, employers and workers. And I think the bill is quite clear that it sets out proposals to simplify the trade union recognition process, which can be quite complicated. And also it wants to introduce new rights for trade union representatives. It says with the aim of ensuring that industrial relations are based on good faith, negotiation and bargaining. So the bill repeals what Labour had previously referred to as the current anti-strike legislation, including that which provided for minimum service levels during a strike in relevant services. And the government's view on that is that the 2016 Act, which is the previous piece of legislation, it basically put unnecessary restrictions and red tape on trade union activity. So as I say, the bill, and it may well be subject to further change as it goes through the parliamentary process, but it does propose to repeal the vast majority really of that 2016 Act. There are two main exceptions to that, again, subject to consultation, but it may well be that it retains the 6-month ballot mandate expiration date. I'll talk about that in a bit more detail further on, and also potentially retain the independence of the certification officer from political control. In terms then of what the key changes would be if the Act is repealed, I think one of them would be the removal of trade unions' obligations to provide certain voting and dispute information in their ballots. There would also potentially be the removal of the requirement for trade union and other associations to pay a levy to the certification officer. The removal of certain investigatory powers of the certification officer following a complaint, and the removal of the certification officer's power to impose financial penalties. Potentially as well, the bill suggested it would also remove the requirement to supervise picketing and the requirement for trade unions to pay for the administration of checkoff, which is payroll deductions for trade union subscriptions in the public sector. In addition, as the slide says, the Employment Rights Bill does include an obligation on employers to give workers a written statement that the worker has a right to join a trade union. And the bill suggests that that should be given at the same time as the employer gives the worker their Section 1 statement, so essentially their contract of employment. So that's quite a significant change. Obviously would be welcomed by the trade unions who say that their members and also non-members obviously should have more information about their right to join them. We've also then got the introduction of access agreements. So the idea here is that we'll have an agreement between a listed trade union and an employer that provides for access to a workplace by one or more officials of the union for what they're calling any of the access purposes. At the moment, what we expect that to be and what the bill refers to is that the access purposes are to meet, to represent, to recruit, or to organise workers, whether or not they're member of trade unions, and also to facilitate collective bargaining. What it doesn't go so far as doing is it doesn't include, for the purposes of what is access, it does not include organising industrial action itself. And it appears at the moment that the right will apply to all listed unions, irrespective of whether or not they're actually recognised by the employer or they have an existing membership within a workforce. So again, quite a significant extension there of a trade union's right to go in and talk to a workforce. Employers will be under a duty to take reasonable steps to facilitate that access, and essentially they'll only be permitted to refuse the access entirely where it's reasonable in the circumstances to do so. We don't know what that looks like yet, but what we do know is that the CAC, so the Central Arbitration Committee, will still have powers, and they would be the person to determine any subsequent disputes that arise from that kind of refusal of access situation. Okay, so if we move on to the next slide, please. So we've also got changes in the process of union recognition and the law around statutory recognition, which I mentioned in terms of thresholds, which the government has said that it wants to simplify. So what they've suggested is an introduction of a power for the Secretary of State to lower the threshold for the CAC to accept a trade union recognition application from its current 10% to somewhere between 2 and 10%. And that will be subject to further consultation. But again, the impact of that could be that there's an increased number of trade unions who can reach that threshold of being recognised by the Secretary of State. Secondly, there's then looks likely to be a repealing of the requirement for unions to show at the outset of submitting a statutory recognition application to the CAC that a majority, at least 50% of workers, which is what it currently is, are likely to support the recognition. And finally, quite a significant one is a change in the percentage required in terms of removing the requirement for 40% of workers in a bargaining unit to have to vote for recognition at the ballot stage, and instead that would be replaced by a simple majority of the workers voting being the requirement. And finally, in terms of trade union reforms, the bill points to the existing time off for trade union activities and a desire to extend that to incorporate equality representatives for recognised trade unions as well. And there'll also be a requirement for employers to provide representatives with accommodation and other facilities for carrying out their duties or for undergoing training for which the employee is taking time off for. Again, there is a caveat to that, and it has to be reasonable in the circumstances. We don't know what that looks like yet, but what we can see is that there's certainly a strengthening of trade unions, not only powers, but their rights to have the employers provide access and also facilities and other supporting measures so that they can do what they see to be their job in the workplace. So as I mentioned right at the start, there's a consultation underway on this as well. And like the other ones we've talked about, quite a tight time frame. If we just move on to the next slide, I'll touch on that consultation briefly. Again, this one ends on the 2nd of December. The consultation is described with the bill as the first steps towards modernising the legislation underpinning this whole area of trade union activity and the rights of workers to unionise. And I think a lot of us would agree that some of the laws around the trade union activity, it is quite cumbersome, it's quite difficult to penetrate sometimes. So a simplification of that might well be welcome in terms of all parties having more transparency about what are the required thresholds. Once the bill has received royal assent, there will be further consultation and the government will then develop detailed policy options. But at the moment, the consultation is seeking views on, as I say, simplifying the amount of information that unions are required to provide in industrial action notices. It's also seeking consultation on removing the 10-year ballot requirement on political funds, consultation on strengthening provisions to prevent unfair practices during trade union recognition processes. And I mentioned the mandate in terms of the expiry of the strike mandate, which is currently 6 months. After that time, a trade union would have to reballot and go out to vote again if there was industrial action planned. The consultation seeks views on whether that's long enough or whether actually that should double to 12 months. And there was a recent BBC article actually from the 23rd of October 24, which does refer to the possibility of that mandate lasting 12 months. And just to give some context of that, the same article referred to walkouts across different sectors and industries over the past couple of years, resulting in more than 5.7 million working days being lost, which is the highest number for more than 30 years, according to official figures. So clearly a very important topic. And the consultation does also seek views on reducing the industrial action notice period and updating the law on repudiation and prior call, and also the enforcement mechanism for that right of access that I mentioned. So do go over to consultation, have your view on that. The government are arguing, as I say, that it would lead to more cooperation and better relationships and therefore lessen the need for industrial action, but we'll have to wait and see if that actually is the outcome. Okay. So I'm just going to very briefly touch on a couple more things. In terms of public sector outsourcing, if we just move to the next slide. If the bill does become law as drafted, what it will essentially do is ensure that employees who transfer from the public sector out to the private sector maintain their terms and conditions, and that any employees supplied by the supplier would be treated the same. And the government has said that this will essentially avoid a two-tier workforce. A code of practice is going to be introduced to provide guidance in relation to relevant outsourcing contracts. Obviously relevant to public sector, but also to private employers who do contract for public services, because it will relate to that as well. It comes from something in the election manifesto where Labour did make a commitment to in-source facilities management services such as cleaning, catering, security within government departments, which would benefit a lot of, for example, members of the Public and Commercial Services Union. That union has said around this time and again we have seen how outsourcing has created a two-tier workforce, a race to the bottom on pay and conditions that disproportionately impacts women and Black workers. So just something to be aware of if there is any link between the work that you carry out and any public services contracts, and look out for that code of practice. And I'll just move on to mention quickly two things that have come out specifically, which again relate to public sector. The provisions that are contained in the Employment Rights Bill suggest that there's going to be a school support staff negotiating body that's going to be established, and its remit really will be to address the remuneration of school support staff, terms and conditions of the employment of those support staff, their training, career progression, for example. And the Secretary of State will be able to refer any of these matters to the negotiating body for consideration, or it doesn't have to do that. The body itself can consider a matter to fall within its remit in certain circumstances. In terms of who that would cover, obviously school support staff will mean people who are employed by a local education authority, governing bodies of schools maintained by local authorities, anyone really under a contract of employment which provides for the person to work wholly or mainly at one or more schools maintained by a local authority or by academies. So the government has extended it to include academies, but it must not be qualified school teachers who obviously already have negotiating bodies set up. And if we move to the next slide, just to quickly mention that a similar body is due to be established for adult social care. Again, matters which fall within its remit will include terms and conditions of employment, social care workers, pay, and what is currently described as any other specified matters. So we have to wait for further guidance on what that means. Social care worker is likely to mean any person who's employed, and that could be at the moment an employee or a worker, wholly or mainly in or connection with the provision of adult social care. That's a defined term within the bill. So I won't go into too much details on that, but obviously if it is something that might be relevant to you, again, look at the guidance, reach out for further assistance from us about what that might mean. Okay, so we've got, yeah, so we're just going to jump, I think, a couple of slides forward. We'll obviously circulate the slides. What I'll just mention quickly is that in terms of equality action plans, currently the position is that employers with more than 250 employees, they have to report annually on their gender pay gap, but there's no requirement to publish an action plan. Now, equality action plans are quite common in the public sector, but what the bill is saying is that employers with more than 250 employees will be required to produce an action plan. Essentially, that will cover matters that relate to gender equality and steps that are taken by an organisation to improve that equality across the workforce. So again, one to watch out for, and we can give further guidance when we've got more details on that.
May, I think just might need to move the slides forward. I think we're slightly out of sync. Keep going, keep going. Sorry. Who's on next steps?
Yeah, we're on next steps now.
Oh, skip that one, thank you.
Okay, thank you. So in terms of where we are then, and what's coming in terms of what the government have committed to publish, in terms of those consultations we've already discussed and what they're seeking the views on. Obviously in progress, we've got those things that are already on the slide that we've talked about. What we haven't got yet is something about employment status and a move towards a single status of worker. That was obviously mentioned pre-bill. We haven't had that addressed. There isn't consultation on that as such yet. And similarly, the right to switch off and work autonomously. We were expecting a bit more detail around that, but that seems to have been pushed back at the moment. So that slide just summarises where we are in terms of the next steps. And again, if you move on to the next slide, May, a few more things that the government has said that it will commit to addressing, that it can do without having to introduce new legislation. You'll see there that there's going to be a call for evidence by the end of the year on unpaid internships. The government has committed to progress their current commitment on paid travel times. That's around working time regulations, what's working time and what isn't. As I've already mentioned, the right to switch off, we're expecting further detail on potentially through a statutory code of practice. And also there's likely to be further information which will come through a charter about supporting workers with terminal illnesses. So they're just a couple of things which we can expect further detail on before the end of the year, which is obviously coming around very soon. It's been busy so far, but it looks like there's more developments to come. So keep an eye out for those. And then if we just move on to the next slide, I think it's just to mention as well that there is also plans to extend the pay gap reporting, which obviously we have at the moment in relation to gender. There is a plan to extend that, so it also relates to pay gaps based on ethnicity and disability. Again, will apply for people who employ more than 250 staff. And there's also, to go in line with this, a plan to extend equal pay rights to protect workers suffering discrimination on the basis of race or disability, because currently equal pay legislation is based very much on gender. It's a type of sex discrimination, but there's a plan to extend that so it's wider, and also to make sure that outsourcing can't be used as a way to avoid equal pay. To regulate that and to monitor that, there's a plan to implement a regulatory and enforcement unit for equal pay. Again, we're expecting further details on this to let us know exactly what that will look like. And I think final slide for me in terms of longer term delivery, we're talking autumn 2026 onwards, so quite a significant time between now and then. But things that are further on the horizon, further review of both parental leave and carers leave. And as I've already mentioned, single worker status is something that we did think might be addressed now, isn't likely anytime soon, as much as it would be welcome by lots of people in terms of having clarity around employer or worker or self-employed. We don't expect anything on that in the next couple of years. Okay, and actually, sorry, one more slide from me. I think, May, if you just Yeah, that's great. In terms of previous government consultations, obviously we've been in these situations before where the government has reached out and asked for views from employers. In terms of the statutory restrictions on the maximum length of post-termination non-compete clauses, so essentially restricting what somebody can do after they've left your employment and whether these should be limited to 3 months. No update on that. Still waiting for further response to that. Reintroduction of fees in the employment tribunals, no update on that. I think internally in the tribunal system, there's some thought that will that still be brought in, given the low fees we were talking about, compared to the burden of implementing that and the costs. So not expected likely, anytime imminently. And finally, a consultation which was launched proposing to make changes to TUPE to clarify that it doesn't apply to workers. Hopefully we will get developments on that. Again, ties in with this single status issue that I've mentioned. It might be that comes first, we don't know. But yeah, that's where we are with those consultations.
Thank you very much. And just, I'm conscious of time, I've got 3 minutes. So we'll save the sting in the tail for the end. Just move to the next slide, please, May. Obviously, the Employment Rights Bill and the Labour government very early on said they were going to increase the remit of the Low Pay Commission to basically do 2 things. They wanted them to include the cost of living when they look at the national minimum wage rates each April. And they also want to look at eradicating or coming up with one adult rate. At the moment, you might remember it used to be over 25 and 23 to 25. We're now currently we have 18 to 20, and if you're 21 or over, that's the same rate for all adults. They want to move to a situation where everybody over 18 gets the same rate. So just very quickly, a lot of you will have seen this in the press last week. On the slide, you've got the current rates. Obviously, you'll have seen there's a 6.7% increase for adults from April next year. It's going up to £12.21. So for anyone over 21. Big increase for people 18 to 20. It's gone by 16.3%. So they've listened to what the government said. They want to sort of reduce the gap between the 18 to 20 rate and the adult rate. So huge increase for people in hospitality and things like that. It's going to have a big impact on them. And that's coming next year. And obviously slight increases, still 18%, but obviously the hourly rates are just lower for under 18s and the apprentices. So at the moment, the guidance is they're trying to get rid of this 18 to 20 bracket. So at some point in the future, that will go and we'll end up with just an 18 and over, which may have an impact on how we recruit people. It might be hard for young people to go into the workforce if ultimately they're against people who get paid the same, who've got lots of experience. So it will be interesting to see. It's another cost for a business. And then if we just move to the next slide, please. This is definitely the sting in the tail. The budget last week, there had been lots of speculation. Labour campaigned very hard on we're not going to increase taxes for workers. So they've really come after employers. There was speculation it might be up to 2% increase on employers' national insurance contributions. Thankfully, it's a little bit lower. It's going up from 1.2, it's going up by 1.2% to 15%. So it is a big change. It also, the big thing that's going to hit employers very hard as well. Currently, there's no employers' national insurance contributions due on any salaries below 9,100. That is dropping in April to 5,000. So not only you're paying more, but you're paying it on more of your workforce. I'm already having calls from clients saying this is going to cost me hundreds of thousands of pounds. So you'll see from the slide, the government predicts this is expected to raise 23.7 billion. I think it's 40 billion shortfall. So that half of it is going to be paid for by employers. So to me, great, we've talked about all the other stuff and we've talked about sexual harassment. This is really hitting people on the bottom line. How are people going to do that? There's a bit there about the employment allowance increasing. It's more of an accounting position, so I'll leave it on there. But this is what I think employers need to be thinking about, because come April next year, you're going to have significant costs added to your business. And I think this will, in what is already a very challenging market, will really struggle and stress some companies out. So you need to be thinking, how can we build these in? Do you currently offer benefits, for example, that don't count towards minimum wage? And things like that, maybe you can bring them in so they actually do form part of your salary. So there's lots of different things you can do. Salary sacrifice might be really, really important, but ultimately, unless you can absorb the costs or pass them on, if you can't do that, I'm afraid it's going to really impact on headcount. So I think we will see some businesses either stop recruiting or look at, do we really need these people? So I think it's tough times ahead. I'm really sorry we've rushed through that, but that's pretty much the last slide. We did have a couple of questions very quickly. If people do need to go, please do. I think it was about what we do with somebody who won't sign up to fire and rehire if they don't agree. That's a big, massive question. Obviously, you either stay as they are, dismiss them and settle it, or maybe find another reason to dismiss them at some point in the future, but you can't go down the route of fire rehire because that would be automatically unfair under current proposals. There's also a question about apprentice rates. It's clear they're still there. The focus is very much getting rid of that 18 to 21, so it's the same for all adults. I haven't heard about them getting rid of the apprentice rate yet, and there's a real drive actually to increase the number of apprentices rather than going to university. So I think that will stay separately. If anyone else has any quick questions, I'm conscious we're slightly over. We're happy to deal with them, but if not, please feel free to follow up with us. I'm afraid it's taken us the whole time, but you've been brilliant. Thank you for sending through your questions that we have had. We will, as Laura said, follow up with the slides, a recording. You'll also get the links to the consultations and any other details. And if you have any questions that you didn't have a chance to raise today, please do put them in an email and we're more than happy to follow up with you. If anyone's at the CIPD conference tomorrow, I will be there in Manchester. So feel free to reach out on LinkedIn. I'm happy to put a name to a face. But thank you again for everyone attending. Thank you for Hayes for collaborating with us. We love working with them. Thanks, Laura, and I hope everyone has a brilliant day. Thanks so much.
Thanks so much. Cheers. Thank you.